All right, we're going to go ahead and get started. Good morning, everybody. I'm Michael Scharf. I'm the co-dean of the law school. It is my great pleasure to welcome everybody to today's Law Review Symposium. This symposium is our annual Law Review Symposium, and this year it focuses on First Amendment issues in education. This is a topic that is especially important to me, as my own decision to become a lawyer was made in the context of what I considered to be an unjust infringement of my First Amendment rights when I was in high school. So I'm going to begin by telling you a story back in time to the year 1980. At that time, I was the editorial page editor of the Shakerite newspaper from Shaker Heights Public High School just up the road. And my dream in life was to become an investigative journalist. And so I was hoping that I could create a portfolio of investigative stories about the high school that I was publishing that would someday get me into a good college and land me that first all-important job. So a couple of weeks into the first semester in this position, I was sitting in a classroom in the first floor of the high school, and I noticed that there were pipes throughout the classroom running vertically, and people had scratched off the coating of the pipes, and other people thought it was fun to pound the pipes every so often and allow a big cloud of white dust to float around. So I went to my science teacher and I took a sample of this, and he said, "Yes, this is what I thought, it's asbestos." And at that time, asbestos was not prohibited, but there were a lot of studies saying that it was going to be dangerous and that there should be something done about that. And I was also on the debate team, and the topic that year happened to be consumer product safety. So I was reading those studies. So I decided to write an article under the rather edgy title of "Our High School May Be Killing Us." So the article comes out. The next day, the principal calls me down, and this guy's name was Mr. Warren Zimmerman. And so Mr. Zimmerman says, "Michael Scharf, all day long I've been on the phone with irate parents who are very upset about your article. And then I've been talking to irate school board members, and I just got off the phone with the superintendent of the schools, and he was really upset. He says, we have a real problem, and I'm going to do something about it." And I'm thinking, that's great. My first really important article has changed the world. And he says, "So you are the problem, and what I've decided to do is make sure that you never write for our school newspaper again." So he threw me off the school newspaper and he banned me from writing. I went home to my parents and I said, "We've got to do something about this. This is unjust, and it's going to alter the trajectory of my life." Little did I know. And my mother, who's a social worker, said, "Oh, honey." My dad, who was a businessman, said, "Do you really want to make this a big deal?" Neither of them knew any lawyers, and they certainly didn't want to bring a expensive litigation on my behalf. So they just convinced me I couldn't do anything about it, and I was dejected, and I focused on other things. But it really made me decide that I wanted to go into law because it felt unjust. And in fact, I will tell you this, every time I write a book or an article, and I've written over 100 articles and 20 books, 6 of which have won national book awards, I channel that feeling of unjustness that I felt at that time. And that gets me through the writing of these large pieces. Those of you on law journals, if you need to write a long note or something, find something that you're really that passionate about. But I don't know whether if we had brought that case, it would have succeeded in the courts. Back then, the jurisprudence was different than it is now. And I know that over the years, it's become harder and harder to win a case like that. But maybe with that case, things would have been different. Anyway, I ended up becoming a lawyer, a law professor, and now for the last 9 years, the dean of this law school. And I am really glad that the Law Review has chosen this particular topic for our symposium. Today's symposium will discuss current First Amendment issues in lower and higher education, recent state legislation, circuit court and Supreme Court decisions, and social movements have impacted our American educational system. And today we have an opportunity to discuss these issues as they have become more timely, well-known, and important than ever before. Today's event will provide a look into topics such as academic freedom protections for teachers, K-12 curriculum and school choice, off-campus speech, critical race theory, and student mistreatment. We will also discuss practical considerations of recent legal developments with practitioners in the education law and free speech areas. Our event today features some of the leading scholars in these practice areas from around the country. We would like to thank the Stanton Foundation and the Attorney Admissions Fund of the U.S. District Court for the Northern District of Ohio for providing support that enabled us to put on this symposium. I'm now happy to turn it over to Kennedy Dixon, the Executive Symposium Editor, for an overview of the day's schedule. I hope everybody has a great time. It's going to be a great symposium. Thank you.
Thank you, Dean Sharp, and thank you all for coming today. I want to briefly talk about why I picked this topic for our symposium. Personally, I'm internally grateful to all the educators that have played a central role in my life. They've instilled a level of learning that I hope inspire and guide our conversations today. In my family, my grandfather was a high school teacher for almost 40 years. And my father, who's here today, has served as a university professor for over 30 years. More broadly, the First Amendment safeguards the right of every person to speak and think freely. These rights are at the heart of the educational process. But rapid social, legal, legislative, and even technological changes have escalated controversy in our American educational system. The limits of the First Amendment protections are being challenged in the classroom for teachers and students alike. As law students and lawyers, this topic is of the utmost importance because we serve as the arbiters tasked with representing individuals in the resolution of these tensions. Our role is to help define the critical rights and responsibilities of participants in the educational process. With that said, I would like to take a minute to thank our moderators and speakers for making time for this program today. We are so excited to hear your thoughts, engage in conversation, and publish some of you in the spring. I would also like to thank a few people who've been instrumental in making this program happen. First, Mr. Eric Seiler, who handled all of our logistical and travel arrangements for today. I would also like to thank our executive board for being supportive of my ideas in making this program happen, and as well as all of our associate editor volunteers for helping me out today. Thank you to Professor Adler, Professor Hill, and Professor Hardaway, as they all helped in the early planning stages by reaching out to speakers and providing guidance to our overall program. And of course, Professor Enton, our law review faculty advisor, has been a constant source of guidance and help with finding funding, speakers, and answering any questions that I might have. Today's schedule includes two main panels. Professor Jaffe will lead the first panel, which will cover K-12 First Amendment considerations for students, teachers, and parents. Then we will have a break for lunch. Then at 1 o'clock, we will reconvene for a second panel led by Andrew Geronimo, our First Amendment clinic. He runs our First Amendment clinic. We will discuss academic freedom more broadly and student mistreatment in the context of higher education. So without further ado, I'll turn it over to Professor Jaffe to bring in our first panel. Thank you.
I'm Dan Jaffe, and I teach education law here at the law school. I also co-author a practical treatise on education law in Ohio, and it's my honor to be the moderator for this distinguished panel. And I'll take a few moments to say a few words. I will introduce each speaker as we go, so that you can remember who they are. And if you would hold your questions until all the speakers are done, we'll have adequate time for questions and answers. So, so with that said, let's remember why we're here, and I'll pull out my Constitution. And the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. So how did this get involved in primary and secondary education? Because while the need for universal education was generally recognized by the founding fathers, in practice at that time, there was no general education requirement. So in his farewell address in 1796, George Washington said that we must promote as an object of primary importance institutions for the general diffusion of knowledge in proportion as the structure of government gives force to public opinion. It is essential that public opinion should be enlightened. And Adams wrote, the whole people must take upon themselves the education of the whole people and must be willing to bear the expenses of it. And yet at that time, there really was no public education. There was private education for the wealthy through private schools and religious schools. Thomas Jefferson put forth a plan in Virginia for general public education paid for by public funds twice, and twice it was rejected. Turning to the 19th century and looking here in Ohio, gained statehood in 1803, and it wasn't until 1825 that the very first tax was enacted for public education, at that time only for buildings. By 1836, there were 468,000 school-age children in Ohio. Of those, 322,000 attended less than 2 months, if at all. At that time, the Common Schools movement was spreading throughout the nation, pioneered by Horace Mann in Massachusetts, and indeed it came to Ohio as well. And in Ohio in 1839, there were 455,000 students attending school, and yet only 7% of high school age students attended high school. By 1970, that was 94%, and it was in 1851 that the Ohio Constitution first provided for a system of education. Along the way, the First Amendment received significant interpretation by the U.S. Supreme Court. While not explicitly on First Amendment grounds, I'll take you through a couple brief landmarks. 1925 was the Pierce v. Society of Sisters case, which established the basic split, the compromise between public education and the state's right to require public education and parents' rights to direct their education, setting up the system of public schools versus private schools. In 1943, the First Amendment came to schools with the West Virginia v. Barnett case, and Justice Jackson's famous words, "If there's any fixed star in our constitutional constellation, it is that no official high or petty can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." 1969 was the Tinker case that said that students do not shed their constitutional rights at the schoolhouse gate. And in 1985 was the Wallace v. Jaffrey case that overturned a mandatory moment of silence on establishment grounds under the Lemon v. Kurtzman test. Fast forward 2002, the Cleveland School voucher case, finding that a voucher system that allowed for private religious educational institutions to participate did not violate the Establishment Clause. And fast forward to the current era, the 2021 Mahanoy v. BL case, setting some parameters for where the schoolhouse gate is in the internet era. And just this year, Carson V. Macon saying not only is it permitted to have a voucher system that includes religious schools, once you have your voucher system, you cannot exclude religious schools. And finally, the Kennedy v. Bremerton case, announcing the demise of the Lemon Test and showing that and establishing that history and coercion are the important factors when we consider establishment cases. In the meantime, schools and the law related to schools is in a state of some disarray. So I'll talk very briefly about Ohio. We have statewide vouchers for private and religious schools. We have charter schools, including online charter schools. We have fights at the State Board of Education, which first passed a resolution condemning racism and white supremacy, and then repealed it in favor of one condemning teachings that seek to divide. We have fights at local school boards over curriculum and masks. And I'd say, all in all, we are in a period of upheaval, all of which our speakers will certainly straighten out for us. Right, Ken? Okay, so let's start with Professor Richard Duncan. Professor Duncan joined the Nebraska Law School faculty in 1979. He's a graduate of Cornell Law School, where he served on the board of editors of the Cornell Law Review. Professor Duncan teaches property, constitutional law, and First Amendment. He is a passionate and enthusiastic classroom teacher whose style is not so much Socratic dialogue as Socratic performance. I'm sorry, performance, Socratic performance art. He spends most of his passion and energy teaching, writing, and speaking about issues such as right to life, religious liberty, freedom of speech, the pursuit of happiness, and other inalienable rights and liberties. Professor Duncan's talk is that entitled "Education is not value free. Indeed, it is value laden. And in a country as divided as ours, we no longer have common values and common truths. We have competing versions of what is good, what is true, what is fair, what is just, what is morally good, and what is beautiful, not to mention whether God exists and whether God's word is relevant to a quality education. And a one-size-fits-all K-12 curriculum cannot serve both or all versions of the good life. His topic is why school choice is essential for religious liberty and freedom of thought and belief formation. Professor Duncan.
I'll spare you the performance art. Okay, so I'm really happy to be here. This is an incredibly good symposium with a number of speakers who are first-rate in their areas, and I'm just happy to be one among many really good scholars and practitioners in this area. So my topic is basically why school choice is necessary for religious liberty and freedom of speech and belief formation. Now, although I think competition is always good for the quality and efficiency of any product or service, my argument today is not about higher standardized test scores or better mastery of subjects and skills. My perspective is based upon First Amendment values of freedom of religion, thought, and belief formation. In other words, I believe that school choice is necessary for religious liberty and freedom of thought and belief, just as it violates the letter and spirit of the First Amendment to directly compel all K-12 school children to attend public schools. I argue that it also violates the letter and spirit of the First Amendment when states create a funding monopoly that de facto compels impressionable children to attend government schools, where they are taught the content and viewpoints chosen by government officials who control the curriculum of the public schools. So if intellectual and religious autonomy are to flourish In a deeply divided, pluralistic nation such as ours, parents must be free to choose an appropriate education for their children without having to sacrifice the benefit of public funding of education. To put it succinctly, educational funds should be directed to children and their parents, not to strictly secular government schools. Now, I'm no Pollyanna. I am not here to argue that existing constitutional doctrine requires public funding of school choice for families who choose to avoid educating their children in government schools. Indeed, as recently as June of this year, the Supreme Court made clear in Carson versus Macon that the states are under no obligation to subsidize private schools. And the court also made clear that the states are free, quoting the court, to provide a strictly secular education in the public schools. So my purpose here is simply to point out that if we take seriously the constitutional ideal of parental rights and neutral pluralism of religion and belief under the First Amendment, the case for equitable funding of school choice for all children is compelling, both the policy case and I think the constitutional case. Now, there are 3 lines of SCOTUS cases that all point towards a right to equal funding for school choice. Mayer versus Nebraska and Pierce versus Society of Sisters make clear that parents have a fundamental substantive due process right to control and direct the education of their children. Thus, a law requiring all children to be educated in government schools is unconstitutional. And the court explained its holding in Pierce with an iconic defense of pluralism and freedom of belief formation that resonates more than ever today. The fundamental theory, said the court, of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny, that is, parents, have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, although this right of parents was recognized by the court in 1925 as arising under the Due Process Clause of the 14th Amendment, in his opinion for the court in 1965 in Griswold versus Connecticut, the contraception case, Justice Douglas declared, this is dictum, but Justice Douglas declared that the right of parents to educate a child outside the public schools in a school of the parent's choice is perhaps best understood as arising under the First Amendment. As Douglas put it, the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge by forbidding education outside the public schools. In other words, the First Amendment guarantees the right of parents to protect their children's right to freedom of thought and belief formation from being standardized by laws restricting these rights, by laws that either in fact directly or indirectly compel children to attend public schools. Now, under the Free Speech Clause, so that's substantive due process and sort of being reimagined as a First Amendment right. Under the Free Speech Clause, the government school monopoly is a brutally coercive system that creates a captive audience of children for compelled educative speech in the content and viewpoints of curriculum chosen by government officials. And this is at odds with established First Amendment doctrines forbidding both compelled speech and content and viewpoint discrimination. And the monopoly also violates at least the spirit of recent free exercise cases, such as Trinity Lutheran, Espinoza, and Carson versus Macon, that made clear that laws that fund secular benefits, such as subsidies to daycare and scholarships for private K-12 education, are unconstitutional if they exclude similar benefits for religious institutions and families. Chief Justice Roberts, and Justice Roberts usually kind of speaks with a quiet voice, with a gentle voice, but he spoke very clearly and strongly in this case. As he put it so clearly in Espinoza, the K-12 scholarship case for private schools, the First Amendment condemns discrimination against religious schools and the families whose children attend them. They are members of the community too, and their exclusion from the scholarship program here is odious to our Constitution and cannot stand. And what I want to do with the rest of my time today is to demonstrate that the monopoly of funding is a brutally coercive denial of these fundamental First Amendment rights involving educational freedom and equality. It effectively forces parents to accept instruction kind of echoing the Pierce opinion, it effectively forces parents to accept instruction for their children from public school teachers only. Now, I have a progressive colleague. I have many progressive colleagues, but I have one progressive colleague in particular who tells me that lived experience is not debatable. Well, I concur in part and dissent in part. I believe that lived experience, although always debatable, often sheds valuable light on important issues of law and social justice. And school choice, the funding of students and their families rather than government school systems, is one such issue of fundamental importance in contemporary America. So allow me to share some of my lived experience as a person of faith and a father of five concerning educating our children in an increasingly secular and increasingly divided nation. A number of years ago, I was asked to speak to a large young parent Sunday school class at a large evangelical church in Lincoln, Nebraska, where I live. And the pastor who invited me wanted me to help these young Christian parents think through their options for educating their children, public schools or private religious schools. So on the scheduled date I walked in, a bit of a wise guy, I walked into the room and explained that since I'm a law professor, I ask questions rather than answer them. So I asked several questions. My first question went like this: how many of you young Christian parents wish to educate your children in a curriculum that reflects the mind of Christ? Now, how many of these parents do you think raised their hand? Of course, every one of these loving parents quickly raised his or her hand. Then I asked maybe some of it was virtue signaling, but then I asked my second question. How many of you believe that the public school curriculum reflects the mind of Christ? So now how many do you think raised their hand? Of course, not one hand was raised in response to that question. And for my third question, I pretended to be confused, sort of went into my Detective Columbo shtick and said, I'm going to have to go home and ask Mrs. Columbo about this because I'm very confused. I said, why did you invite me here to help you think through your decision if you have already decided that the public schools are not appropriate to the education of your children? And in frustration, many of these just young Christian parents exclaimed, and you know what they exclaimed, but we cannot afford to send our children to private religious schools. There's the rub. We hear a lot about systemic inequality lately, but there is no greater systemic inequality than an educational funding system that provides a K-12 education only for those who wish a progressive secular education for their children in the public schools. The selective funding of education in secular government schools guarantees religious inequality in America. It imposes on religious parents what even supporters of public schools call a brutal bargain. Religious parents must choose between the single largest benefit most families receive from local government and their right to educate their children outside the government schools. In my lived experience, the government school monopoly is a brutal bargain indeed. It was a brutal hit for my family's finances, and I've been blessed with a law professor's income, so I don't really worry about people like me. How much more brutal is it for parents trying to raise large families on a lower working class income? The poorer the family, the more brutal the coercion of the monopoly. But here's the math for someone like me, a Christian father of 5 children, for whom a secular progressive curriculum is inappropriate for my children because it undermines much of what my wife and I believe about things in life that matter a great deal and things that we think our children ought to be taught. Now, in my home state of Nebraska, the average per pupil funding for K-12 education is a little over $13,000 per year. So $13,000 times 5 children times 13 years. Do that math in my head real quick. No, I got it written down here. $845,000. That is the penalty someone like me would pay for educating their children in private religious schools. If you send them to the government schools, you get $845,000 for your children's K-12 education. If you enroll your children in private religious schools, you lose every penny. That is a brutal bargain indeed. The combination of mandatory attendance laws plus the educational funding monopoly for government schools guarantees a captive audience for the so-called common values, viewpoints, and knowledge selected by state legislatures, local school boards, and other government administrators and officials, and the interest groups that lobby them as well. Moreover, the Supreme Court's Establishment Clause jurisprudence strictly forbids any curriculum in the public schools that encourages or endorses religious ideas or values. Thus, the public school system is not and cannot be a religiously neutral system of education, neutral between religion and non-religion. The public school curriculum is an engine of secularization. Professor Michael McConnell captured the hopelessness of religious parents when he observed, a secular school does not necessarily produce atheists, but it produces young adults who inevitably think of religion as extraneous to the real world of intellectual inquiry, if they think of religion at all. The focus is constantly on a secular perspective, a secular understanding of everything that comes up in a typical school day. And perhaps no one has understood more clearly this reality concerning the government school monopoly than John Stuart Mill, who put it this way in 1859 in his iconic treatise on liberty. All that has been said, says Mill, of the importance of individuality of character and diversity in opinions and modes of conduct involves, as of the same unspeakable importance, diversity of education. A general state education is a mere contrivance for molding people to be exactly like one another. And as the mold in which it casts them is that which pleases the predominant power in the government, whether this be a monarch, a priesthood, an aristocracy, or the majority of the existing generation, in proportion as it is efficient and successful, it establishes a despotism over the mind, leading by natural tendency to one over the body. Despotism over the mind, says Mill. Instead of schools run by government, Mill supported what he called diversity of education and parental choice. So I think we need to ask a few questions in deciding whether the government school monopoly is consistent with at least the spirit, and I think even the letter of the First Amendment. Since time is short, here in a nutshell is my take. I fully realize that as recently as this past summer, the Supreme Court has made clear, at least in its dictum, that a government may adopt a strictly secular curriculum in the public schools and has no obligation to fund private K-12 schools. So at least for the foreseeable future, the Supreme Court's First Amendment doctrine will not relieve parents of the brutal bargain imposed on them by the government school monopoly. However, this coercive take it or leave it system of funding education is inconsistent with both the letter and the spirit of the Free Speech Clause and the Free Exercise Clause. As Mill observed, it results in a despotism over the hearts and minds of our children and eradicates the rights of parents to control the education of their children. It violates the spirit of freedom of speech by forcing parents to substitute the preferred viewpoints of government officials for their own, concerning fundamentally important ideas about history, government, justice, sexuality, gender identity, and many other topics arising in the course of the K-12 education. Moreover, because the government school curriculum is strictly secular and is required to be under Supreme Court case law, this funding monopoly inherently forces religious parents to choose between their faith. Think about the parents in the Sunday school class that I mentioned, forces religious parents to choose between their faith and their ability to educate their children as they think best. Such religious discrimination is odious to both the letter and the spirit of the Free Exercise Clause. So let me just close with this. Some would argue that school choice results in non-believers being taxed to fund religious education for believers, and that this is unfair to non-believers. Well, is that true? Is equal funding for every child's education somehow preferential funding of religion? Unlike public schools, which, as we have seen, are most definitely not neutral between religion and non-religion, and I have no beef with the public schools. If the people they work for, there's a lot of wonderful professionals who teach and administer in the public schools. I don't have a beef with them. I'm just saying they're not for everybody. So unlike public schools, which we have seen are most definitely not neutral between religion and non-religion, school choice for each child is strictly neutral because everyone, regardless of their religious or non-religious views, gets equal K-12 funding. Indeed, Michael McConnell and Richard Posner take the position that equal funding of school choice is necessary for neutrality and systematic equality. They explain the economic impact of school choice this way. No one is taxed to support the religious education of another. Rather, each person pays one lifetime's worth of taxes earmarked for education, and in return receives in advance one education. Of course, things would not work out as neatly in practice as they do in this very abstract model. There would still be a subsidy from rich to poor, but there would be no systematic transfer of wealth from individuals who attend religious schools to those who do not. On the contrary, to force individuals to pay educational taxes, but deny them education financing because they have chosen a religious school brings about a systematic transfer of wealth from the religious to the non-religious. And if my math is correct, it is a large transfer of wealth. So what they're saying basically is rather than focus on parents paying school taxes, the focus should be on each child. Each child gets one free K through 12 education in a public or private school of the family's choice, much like a school loan. And each child pays a lifetime of taxes to repay that loan. Everyone gets one, and everyone pays for one. Secular citizens do not subsidize religious citizens, and religious citizens do not subsidize secular citizens. At one time, a neutral school choice program that included private religious schools would have been struck down as a violation of the extra-constitutional wall of separation metaphor. But today it is abundantly clear that a neutral school choice program funding both secular and religious private schools is valid under the Establishment Clause. Of course, the Cleveland school choice case, Zellman versus Simmons-Harris, in which the court voted to uphold a school voucher program that involves true private choice and provided neutral educational assistance directly to a broad class of individuals, defined without reference to religion, is the leading case, but the court has said the same thing time and again since then. In other words, states may fund private school choice programs if they wish to do so. The important question for the courts to decide today is whether the First Amendment requires states to fund all K through 12 educational choices. School choice, by the way, may also be the solution to the public school curriculum wars that are taking place across the country today. In a pluralistic and deeply divided nation, such as America in 2022, a one-size-fits-all curriculum is doomed to fail and to deeply politicize the public schools. A one-size-fits-all curriculum, especially one covering issues such as systemic racism, white privilege, gender identity, marriage, abortion, and many other hot issues, will always be deeply divisive and destructive of community in government schools. School choice allows dissenters to vote with their feet rather than to fight over the curriculum and books in school choice and books in school libraries. It's like the old cigarette commercial, I'd rather fight than switch. In conclusion, the letter and spirit of the First Amendment deeply values freedom of religion, speech, thought, and belief formation. If these values are to survive in our deeply divided pluralistic nation, parents must be free to choose an appropriate education for their children without having to sacrifice the benefit of public funding of education. School choice, in my opinion, is the civil rights and civil liberties issue of this present age. And one way or another, either in the courts or in the states, we need to get there. And with states increasingly funding school choice scholarships, it gives young families the choice of voting with their feet and moving to states with school choice. Federalism and foot voting are beautiful things and enable lots of choices of how we're governed. Foot voting, by the way, is the most effective form of voting because it immediately gives you the right to become a new citizen of a state with laws and benefits that are best for your family circumstances. And states with school choice laws will attract families with children. So that's what I have today. Thank you, and I look forward to your questions.
Thank you, Professor Duncan. Do we have Professor Wilson available? Okay. Oh, great. Erica Wilson is a professor of law. She is the Wade Edwards Distinguished Scholar and Thomas Willis Lambeth Distinguished Chair in Public Policy at the University of North Carolina School of Law. Her expertise includes civil litigation, civil rights, clinical legal education, Critical Race Theory, Education Law and Public Policy. Professors Wilson's scholarship focuses on issues related to education law and policy and the intersection between race and the law. Her scholarship has appeared or will appear in the Harvard Law Review, Yale Law Journal Forum, Columbia Law Review, Cornell Law Review, and the UCLA Law Review, among others. Professor Wilson's work was selected for presentation at the Harvard, Yale, Stanford Junior Faculty Forum in 2017 and again in 2022. She was awarded the James H. Chadbourne Award for Excellence in Scholarship from the UNC School of Law. In 2020, she also founded the Critical Race Lawyering Clinic, a clinic that teaches law students how to bridge the gap between critical race theory and praxis. She is an avid USC football fan and a Los Angeles Lakers fan, hopefully a LeBron James fan for us here in Cleveland. All right. Professor Wilson will, her talk will consider the attacks on the so-called critical race theory in the context of the debate on localism in education. When local school boards determine curriculum, allowing local communities to chart their own course, she considers whether that perpetuates racial inequality and anti-democratic preferences. Professor Wilson.
Hi, everyone. Can everyone hear me? Okay, good. Well, thank you for having me. I'm very sorry that I couldn't be there in person today, but I am looking forward to a really engaging conversation. Since I can't be there in person, I'm actually going to share my screen and show some slides because I know maybe you don't want to just stare at me. So bear with me for 1 second. All right. So hopefully everyone can see the slides. It's hard not being there. Thumbs up if you can see the slides. All right, good deal. All right. So the subject of my remarks and paper are about the so-called critical race theory bans and considering them in the context of education localism. And so this actually dovetails nicely with what Professor Duncan was talking about in terms of school choice and the ability to vote with one's feet. Our system of education localism has actually created a patchwork system within states of so-called anti-CRT bans. And I argue it has some effects on how education can be used to enhance our democracy. So that's what I'm going to talk about today. I'm going to spend the first third of my time giving some context for this principle of education localism. Then I will situate some of the CRT actions that are happening in my home state, North Carolina, within the context of education localism. And then I'll conclude by talking about the implications for democracy of this patchwork of anti-CRT actions or pro-CRT actions as well for education's ability to play a enhancing role to our democracy. So I'll start by talking about education localism. And the first thing that's really important to note here is what localism is. And so I use the term localism to mean an ideology that favors decentralized independent local government structures over more centralized government structures. One of the central tenets of localism is that the provision of government services should be controlled locally with the interests of local residents as the exclusive or primary exclusive focus of local decision makers. In the context of public education, as Professor Duncan alluded to, public education has the potential to restructure the relationship between parents and children, to introduce new ideas and values, some of which may conflict with parental ideas and values. So one of the central tenets of localism as far as education is concerned is that vesting the provision of education in the lowest level of local government, which usually turns out to be a local school district puts education decision-making ideas and policies closer to the family level, to the extent that local parents have the ability to influence education policy, some of which we see with the debates about CRT and the curriculum in public schools. And so in the context of education, although all 50 states contain an education clause that mandates the creation of a public education system of schooling, usually through the 12th grade, most states delegate that responsibility down to the lowest level of local government, which is the school district, and they empower school boards that govern school districts to make various education policies. And the level of locality varies, with some districts being municipally based, some being county based, and others even being regionally based. And so I put up this picture for you to give some context to what I'm going to say after this, is that there are approximately 16,800 local school districts. The blue lines on the map represent every school district in the United States of America. You can see some geographical differences within the Northeast and the Midwest, there being many more lines because there are more municipally based school districts in those areas. In the South and West, there are fewer lines, mainly because they are more likely to have county-based school districts and in some instances regionally based school districts. To the extent that some of the nitty-gritty decisions about education policy actually get made at the local district level, the local school board level, this has important implications in the public school setting for what is actually being taught on a curricular level. And we'll see that with the actions that various localities have taken with respect to so-called critical race theory bans. And so the practical import, as I alluded to, is that these local districts bear great responsibility for the day-to-day education that students receive, including school assignment and curricular decisions. I've excerpted an example of North Carolina's constitution, which sets up a state board of education, which then empowers the state board of education to make any rules and regulations needed. And usually that ends up happening, being delegated down to local districts here in North Carolina, at least. Critically, the justification for the system of education localism is nicely set out by the Supreme Court in Milliken versus Brantley, and also in several other Supreme Court cases, where the court has said that local control over the operations of schools is critical. It gives the ability for citizens to participate in the decision-making process, permits the structuring of school programs to fit local needs, and encourages experimentation, innovation, and a healthy competition for educational excellence, meaning that when we have local school systems that are structured differently, citizens can vote with their feet. There can be an interlocal competition between localities for students based on what it is their district does, what they offer or do not offer that may attract parents. Now, there are usually state standards. Every state has standards and there's some standardization, but what we find is that there is local district variety that can and does influence parental decisions about where they will or will not send their children to school. And so the really important justifications to tease out of this is citizen participation in education decision-making process, the interlocal competition I talked about, and critically for purposes of thinking about the CRT actions is this idea that you can accommodate our national pluralism and diversity in educational preferences, that parents have differences in what they want their children taught or not taught, and that the system of localism, to the extent it allows parents to vote with their feet, is the best way for a system of public schools to accommodate this pluralism. There's also the idea that there's greater accountability. If you are unhappy with what's happening in your children's schools, as we've seen again with the CRT debate, parents can go to their local school board meeting, express their preferences, and are more likely to have their preferences met. But there are some really important critiques of localism that I argue come into play when we think about the CRT actions, both the bans and the positive decisions to incorporate some forms of CRT into curriculum. And I should pause by saying that I'm calling it CRT bans or positive affirmations, but in reality, it's not really, or technically most K through 12 schools are not teaching critical race theory, but this is the label that's been placed on decisions about how we will talk about race and inequality in school curriculum. But the critiques of education localism suggest that it permits inequality between school districts, right? One thing that I haven't talked about, a key principle of localism articulated by the Supreme Court in the Rodriguez decision is that schools can be funded locally based on the tax dollars that are in a particular local district, which creates serious funding disparities. It can create disparities in the quality of teachers, et cetera. So the idea that we're going to vest local control allow some kinds of disparities and inequality to persist. Most important for what I'm going to say today is that I think there's an argument that it also breeds myopic understanding of community and belonging. If people can sort themselves in communities that suit only their preferences, schools that only suit their preferences, it can in some ways undermine the purposes of public education in terms of melding a diverse group of persons together and making them citizens with empathy and understanding. To that point, it also can fail to situate our students to live in our racially diverse and pluralistic country, which is becoming increasingly important as the country becomes increasingly more diverse, both along the lines of race, class, religion, ethnicity, et cetera. And so, in a nutshell, one of the main critiques of localism is that given the ethnic and economic divisions between localities, characteristics of many metropolitan areas, there is the danger that education localism can turn into local particularism and result in the propagation of parochial local values inconsistent with the broader goal of education for life in a diverse and multicultural society. And so I want to use North Carolina as an example of both the pros and cons of education localism, specifically using local anti or pro CRT actions as an example. So in North Carolina, the North Carolina State Legislature attempted to pass HB 324, which was a bill that purported to ban the teaching of critical race theory in school. And so you can see I excerpted a small portion of the proposed bill that many of the things that public school units shall not promote are things that came from the Trump executive order. Can't promote that one race or sex is inherently superior. An individual by virtue of his race or sex is inherently racist, sexist, or oppressive, etc. What happened in North Carolina is that HB 324 got through the legislature, but was vetoed by a Democratic governor. So HB 324 did not pass. But what we saw happen after HB 324 didn't pass, even though the state bears responsibility for education, I mentioned earlier, our system of localism means that it's some of the practical education policy decisions are actually made by individual boards of education who have control over local districts. And so what we saw happen was the North Carolina State Board of Education approved new social studies standards. And the new social studies standards set forth some objectives about how various principles in social studies should be taught. The policies were aimed at having a more inclusive version of social studies, and it met a lot of consternation in various local communities. And so the combination of the state bill on banning CRT not making it through, along with the State Board of Education standards, led to many local boards creating their own either resolutions or policies that essentially sought to do the same thing that HB 324 did at the local level. So subverting the state bill being vetoed and instead enacting these local resolutions or school board policies that had the same effect. So what we saw in North Carolina was that there were 19 total actions related to critical race theory. 15 were anti-CRT, 4 were pro, 7 were actual school board policies, some were resolutions, 6 were actually resolutions, 2 were superintendent statements, and then the last 4, the 4 in the remaining boxes were purported to be pro-CRT actions. And so we saw 1 Black Lives Matter week of action, 1 pro-school board CRT school board resolution, required equity training, and 1 teacher equity grant application program. So I think it was fair to say the anti-CRT actions had a more direct effect on the curriculum than the so-called pro-CRT actions that were taken at the local level. But here's an example of one of the resolutions that was passed in one of the counties, and you can see that it's almost verbatim the same as the House bill that did not pass. The important part for my analysis here is understanding the geography of how this happened, where these things happened. So the 19 actions are depicted in the colored county boxes. The yellow is where we had anti-CRT actions, and the orange is where we had pro-CRT actions. And you can see there are these clusters of pro and anti-CRT actions, creating, as I mentioned earlier, this patchwork of different localities doing different things in terms of how they were going to handle their curriculum. And so this definitely tracked race. I couldn't put all of the county demographics on this very limited slide, but the first 3 counties depicted on the slide were anti-CRT actions were taking. And most of these localities were overwhelmingly white with the smaller number of students of color. The one pro-CRT action that was taken in Durham County was more of a racial plurality with less than 50% white and over 50% students of color. And so a summary of the demographic information shows that in the 15 counties that took anti-CRT actions, the student bodies in each of the counties was at least 65% white. In the pro-CRT actions in those counties, the student bodies were at least 40% students of color. There were also political divisions in 14 of the 15 counties that took anti-CRT actions. Trump garnered more than 50% or more of the electorate vote. On the 4 counties that took pro-CRT action, Biden garnered 50% or more of the electorate vote. And so this, I argue, has really important implications for this concept of education localism, and more importantly, implications for our democracy. One thing that often gets lost in this conversation about education and curriculum and what will or will not be taught in schools was that the system of free public schools developed mainly for the purposes of supporting American democracy, inculcating students, future citizens, with certain civic virtues and values. The founders believed that a system of publicly operated schools would be the best vehicle for melding students from a wide swath of backgrounds, inculcating a shared civic virtue, and turning young people into competent and virtuous citizens. And so what we have now is a burgeoning multiracial democracy, I argue. Our previous conceptions of democracy at the time that our free system of public education was developed was not a true multiracial democracy, because we had express laws prohibiting non-whites from fully participating in the democracy and being true citizens. So we are now attempting to have a true pluralistic multiracial democracy. And for that reason, education is going to play a vital role in whether or not we can successfully do that. And so in a democracy, state-sponsored education is supposed to create citizens by inculcating shared community and preparing students for the responsibility of citizenship. And so I suggest that the assault on CRT in some ways is a thinly veiled threat against those deemed by the majority to be outside the sphere of citizenship in terms of how we see our history, what our students or our children are being taught or not taught. The state, however, I think has an obligation to teach students respect for opposing points of view, to provide them with the intellectual skills necessary to evaluate ways of life that are different from their parents. And so,
I didn't get that.
sorry about that, my Siri watch. But when we look at the CRT actions, it raises a question then, if that's the purpose of education in our democracy, whether or not these CRT actions are actually a form of healthy education localism at work. One could argue that localism, education localism, is a way for maximizing it's worked in this sense. It's maximized the democracy enhancing functions of public education by allowing parents to have a voice and to make a difference at the local level in terms of the curricular changes. The communities disagreed with the state standards and participated in their local process to get clarifications that suited their communities. These smaller units of government allowed for their preferences to be accommodated, and given the reality of interlocal competition and resident sorting, maybe it's not a bad thing that we have this patchwork of anti and pro CRT actions. The converse argument to that is that it may also be an example of what I call destructive localism at work. Destructive localism, I argue, occurs when groups enjoy local autonomy, but they do so in ways that results in them forming racially and economically homogeneous community, taking advantage of the benefits of being connected to a larger network of municipalities, and inflicting tangible and or intangible harms on neighboring localities. So what's the harm here that I argue? I argue that the harm, the CRT bans arguably effectuate new and equally pernicious forms of destructive localism through the propagation of parochial local values inconsistent with the broader goal of education for life in a diverse and multicultural society. Given the varied lifestyles and cultural preferences, the counter argument goes, CRT actions are a healthy sign of American freedom and choice, not destructive or exclusionary, because it demonstrates the ability of America's varied communities to find solutions that work best for them. I actually conclude by suggesting the answer is somewhere in the middle, right? Some local variations can be a positive and further the positive benefits of education localism that benefit the American democracy. However, some of the local actions in practice, I didn't have enough time to talk about it, have turned out to be effectively memory laws, which enshrine state-approved interpretation of crucial historical events and promote certain narratives about the past, and will certainly shape future citizens' views about the future. I conclude by suggesting that we have to walk a careful balance between the local autonomy and destructive localism being used to inculcate students with values that threaten our burgeoning multiracial democracy. So I am right at time. So I will stop there and I look forward to hearing any questions folks have.
Thank you, Professor Wilson. Of course, we'll have a question and answer session after all the speakers are finished. Our next speaker is Emily Spivak, who is a senior associate at Squire Patton Boggs, where her practice focuses on issues facing employers in public school districts. Emily's practice includes advising school clients in student discipline matters, special education disputes, contract and policy drafting, and employment questions. She regularly defends districts before the Ohio Civil Rights Commission and the U.S. Department of Education's Office for Civil Rights. She also has extensive experience in public records and public meetings questions, both under Ohio's Sunshine Laws and the Federal Freedom of Information Act. Most important, Emily is a 2011, 12, 13 graduate of Case Western Reserve School of Law, where her favorite class, I am certain, was Professor Jaffe and Professor Carney's education law class. She also had the unenviable experience of working with me at Squire Patton Boggs for a short period of time. Emily will describe day-to-day First Amendment challenges facing public schools. She'll describe the interplay between student and teacher free speech rights that she's encountered in her practice. Topics may include student publications, presentations, student artwork, social media, school libraries, dress code enforcement, and teacher professional conduct. Emily.
Jaffe. All right, so as Professor Jaffe said, my role today is to talk about some of the practical issues we see day to day in schools. And so I'm going to do a quick overview of some of the applicable law, just so we have a framework to work from. And then mostly I'm going to throw out some stories that we can discuss a little bit later, and I'm sure my fellow panelists will have thoughts on as well. So as I start, much of what I'm going to talk about today has actually been pretty well established law for a long time. And what we're seeing now is an effort to try and redefine it in some ways, and then also try to fit our modern world into old standards and customs. So first, let's talk quickly about the basic parameters of public school students' rights. We have Tinker, the substantial disruption test. That's what we deal with the most. And then, of course, we have the fact that schools can prohibit student speech that promotes illegal drug use, oddly specific, but it does come up. Speech that is lewd, vulgar, or profane and occurs on school property. Key note there. Speech that is considered school-sponsored. So if it's part of a school-sponsored publication, for example, then that can be regulated. I don't know if Professor Sharp is still here, but I was the editor-in-chief of the Shake Right when I was in high school, and that was a designated public forum. So schools can designate certain school speech as outside of the school's review, and when they do, it is not school-sponsored. But what is happening in schools as curriculum can be regulated as school-sponsored speech. And then the final point is what we just got recently: speech that constitutes a threat aimed at students or staff, severe bullying or harassment, plagiarism, or similar offenses. And that's where we get into the question of how far can we reach off campus to address some of those issues. But that's our most recent addition to school regulation of student speech. On the employee side, and I will say it is much more complicated than what I have up here on the slide, but just to give a very quick and general overview, public employers are, of course, subject to the First Amendment, but there has been some effort not to disadvantage the public employer over private employers. So there is an understanding that when you are speaking as an employee, when you are going about your work as an employee, your employer has some right to control what you're saying and doing. So we'll talk about some examples of how far a public school district can go in regulating employee speech, and how some of what's been happening in recent years fits into this analysis. Okay, I want to highlight quickly some special rules we have in Ohio with regard to public employee speech. So for teachers and other licensed professionals in schools, they are subject to the licensure code of professional conduct. There may be some arguments that the licensure code might go beyond what the First Amendment would actually permit employers to do, but there are restrictions on employee speech contained in the licensure code. And so you see here, Principle 9 of the licensure code, which was only added in 2019. I think that's how long it took the state of Ohio to realize that social media was a thing. And teachers are out there doing all sorts of things on social media that we'll talk about in a little bit. But this was an effort, a pretty explicit effort, to regulate employee speech, not just on campus, not just in the course and scope of their job, but very broadly. This is intentionally broad enough to encompass personal speech on your personal social media accounts if you are a public school employee in Ohio. And the ramifications of this can be pretty serious because teachers can lose their licenses for violating Principle 9. The range is up to a 5-year suspension of your license. And during that time, of course, you wouldn't be able to teach in a public school. So this applies in Ohio. And then as a result of this, we saw board policies going into effect to try to mirror some of that language. And so we do have language regulating what staff members can say, particularly in relation to their work in the district. And then we have the specific social media policies. And you'll see that the language in these policies hews closely to Principle 9. Again, an explicit effort to reach off-campus, non-employment related employee speech. Yeah, and so there are some First Amendment concerns with that, of course, but as you'll see from some of the examples from an employer perspective, it can come in pretty useful. Other rules that come up in these policies, of course, that staff members may only use district technology resources to access social media when done for school purposes. So that's a bit of a regulation on the teacher's time at school. Don't be on your personal social media at work. There are general school rules for behavior and communication that apply to staff use of social media. And then the disclosure of personally identifiable information about students is, of course, prohibited. I wanted to throw this slide up. This is more attempt to regulate staff members online. This, I think, is a useful discussion point as we move into Q&A later, but attempting to require that staff members at all times be polite, courteous, and respectful online. I'm sure we all have exactly the same definition of what polite, courteous, and respectful means, right? Clearly defined. Not engaging in personal attacks, that's a little bit easier to define. Not harassing another person, that's probably the easiest to fit within our current First Amendment jurisprudence, and not to cause damage, disruption, and that sort of thing in school. So those are the parameters, really, for the examples that I'm going to talk through at this point. So starting with spoken and written expression in schools, and I'll just say, these were some of the examples I have seen in the last few years. There are countless. So looking first at some student speech concerns, we'll contrast two things. The 2016 election was exceptionally difficult for schools. It was difficult, I think, everywhere. But everything that we saw playing out in the national discussion was also playing out in school buildings. And so we did have a group of students. One district comes to mind, although this happened in several of my districts, where a group of white students in a pretty homogeneous district went up to their Latino classmates and told them to go back to where they came from. Okay. This was speech that the district addressed and disciplined because they did so under their anti-harassment policy. This was targeting others based on their race. And so we were able to address it, although it was difficult because, of course, the argument was that public figures were out in the world saying and doing the same things with no repercussions. And so there were a lot of conversations about how the school environment is different from being out in the world. Although you don't concede all your First Amendment rights at the schoolhouse gate, you concede some. By contrast, we get to the 2020 election and students are wearing MAGA hats, Trump gear, promoting, President Trump's reelection, and other students didn't like that, right? They went to the office, they felt that this was, harassing in and of itself, that nobody should be promoting these views, and so on and so forth. There's nothing a school can do about this, right? This is straight political speech. This was protected under Tinker. When we look at material and substantial disruption, we are talking about hundreds of calls to the office. We are talking about news crews on the front lawn. We're talking about students walking out. We're talking about serious threats to safety. We're not talking about 20 or 30 kids saying, I'd rather vote for Biden. That's not a material and substantial disruption. And so we have seen varying versions of these two scenarios play out pretty much constantly over the last 6 years or so. And so districts are consistently having to toggle between these two approaches. On the employee speech side, with similar facts though, we've had different outcomes. So after George Floyd's death, in one of my districts, an instructional aide who happened to be Black posted on her personal Facebook page in support of the Black Lives Matter movement. Nothing inappropriate in the post itself, just expressing her support for the movement. She happened to be Facebook friends with a colleague who was a teacher, and the teacher responded to the post, accusing the aide of being anti-police and expressing support for police officers. Had it ended there, I likely would not be talking to you about this. But what ensued was an 18-hour back and forth between the teacher and members of the community who spoke up in favor of the aide and support of not just the Black Lives Matter movement, but more importantly, the aide as a human being. And the teacher spent 18 hours telling parents and community members that they were stupid, that they were idiots, that they didn't know how to deal with their children, that the aide was just an aide, not a teacher, and therefore did not matter, that they shouldn't be supporting her. I don't know about any of you. I could not spend 18 straight hours on anything, let alone a Facebook conversation, but that is how this woman chose to spend her time. And I think there is a valid question as to whether the district could have imposed discipline under the First Amendment. But at the end of the day, this teacher could not return to the classroom in that district. She's no longer working. This was a 25-year teacher who recognized that she needed to move on. She had lost all credibility in that district. Now, push comes to shove, like I said, could I have defended a termination on that basis? I don't know. Perhaps my colleagues have some thoughts on that. But this was not somebody who could remain in that position and have credibility at the head of a classroom. So part of what we look at in the practical realm here is this is a teacher who would have been instructing a diverse group of students. And the second a student of color walked into her classroom and got a bad grade, she would be questioned, having had this conversation very publicly online. And so there are considerations in addition to the question of, under the First Amendment, hypothetically, can she say this? Then we get into the practical reality of, still, what does that mean for your job? Another scenario was following the insurrection at the Capitol. We had a bus driver remark to her aide that she wished she had been there so she could have taken out some Biden supporters. Not really a direct threat, right? The event had ended. Taken out, I suppose, could be interpreted in different ways. But the aide, being a Biden supporter, wasn't thrilled with this comment. And the district was diverse enough that there were certainly Biden supporters who would be waiting at bus stops with their children. And so the aide reported this comment to the administration, and the driver, believe, was issued a reprimand, because at that point you are promoting violence in the school setting. Now, again, I think it is up for debate if that driver had really challenged it, whether that would have held. But at the end of the day, sometimes schools they have to at least be on record as saying, we don't want our employees making these kinds of statements. Okay. More recent example, dealt with a Black administrator who had shared a video on her personal Facebook page. It was actually quite well done. It was a song about being a Black woman in the workplace and what it's like to be in that position. And really what it came down to was some of her white colleagues, it must have hit a little close to home. Let's just be honest. That's probably what happened, right? But they were sad. They thought they were her friends, and they took this as a personal attack. So the principal and the superintendent met with her about this and suggested that she take it down, which ultimately she did, I'm a little sorry to say. That is not a scenario where I think the district had any First Amendment grounds to stand on. The song was not inappropriate in any way. There was not inappropriate language. There wasn't threatening language. There wasn't anything questionable in it. It was clearly on her personal Facebook page, and it didn't cause any kind of disruption in school. But ultimately, she did take the post down. By contrast, we had last year a school where the masking policy was sort of going in and out, and parents, there was a group of parents that was extremely upset anytime the masking policy was in. I'll talk in a minute about the argument that masks themselves raised First Amendment issues, but we litigated that whole mess. And in this case, this poor elementary school principal, she would retweet, schools closed, right? She would retweet the superintendent's announcements about the district. She would retweet her building's announcements, about what was going on in the school. And this group of parents just went after her on her personal Twitter page. So she blocked them, her page, and they came back threatening a lawsuit, alleging that simply because she was a public employee, her page became a public forum. Interesting concept, but if you take that to a logical extreme, it would never work. You can't possibly assume that every time a public employee speaks in a private capacity, they are somehow creating a public forum just by virtue of their public employment. That's what we argued, and we did win on that one, which I was pleased to see. But it does get a little dicey when she's retweeting everything from the public account as well. So I am constantly emphasizing to public employees that they should not be identifying their public employer or associating their employment with their private social media pages, because it just creates a lot of confusion around issues like this. Okay. So turning to symbolic speech in schools, we have some frequent flyer symbols, which I'm sure will come as no surprise. The Confederate flag, I don't know if it's a resurgence or if it has been this popular consistently, but in the last few years, I get a million Confederate flag questions. And courts have basically said, in school districts where there is a history of racial unrest, the district can regulate the Confederate flag. It can say, you're not allowed to wear Confederate flag gear. I have one district that called a few weeks ago because some kid was flying a giant Confederate flag off the back of their car in the school parking lot. That caused some consternation. When confronted, by the way, that kid claimed they had no idea what the Confederate flag meant, took it down. I don't know. But in districts where there's no history of racial tension, racial unrest, racial violence, there's not much the district can do when it comes to the Confederate flag. And we've seen the same kinds of analysis on Black Lives Matter gear, on MAGA gear, on LGBTQ pride gear, on straight pride gear, thin blue line attire we saw come up in the last few years. All of these symbols that send messages about one's political, social beliefs. There's very little a district is going to be able to do, at least in the student context, when there's been no history of unrest. There is some question whether schools could regulate it a bit more in the context of an employee, right? We have more control over employees and their dress code as it is, but it's very important at that point to be completely content neutral. So we've seen where employers have dress codes that say, you can't wear any political messages, you can't wear anything with words on it, but they don't enforce it until somebody walks in with a Black Lives Matter shirt or a thin blue line shirt, right? You're not gonna be able to enforce it at that point. So while we have more leeway with employees than we do with students, what a lot of districts found is that they hadn't been enforcing these policies all along, and they had basically lost the option to do so. I do want to touch on masks, although we have, I hope, mostly moved past this issue. It seemed for a while there that I was spending all of my time briefing on the First Amendment implications of requiring people to wear masks. And so the threshold question there was, does a masking policy constitute compelled expression? And courts across the country essentially concluded no. This case I have up there out of Maryland, I thought put it most succinctly, which was to say, wearing a mask right now, and this was in 2020, conveys nothing other than you don't want to get COVID, or you are complying with a masking requirement, not so it wasn't expressing any other kind of view. There may be an argument now sometimes that wearing a mask is expressing more of a view, but I think the courts have been clear that that was not compelled expression. And then courts went further to say, even if it was compelled expression, did the government have a compelling interest in implementing that? The answer was yes. And so the roughly 150 parent letters I had to respond to complaining that districts were violating their children's First Amendment rights all went something like this. Now we get to student artwork, and these examples are fun. This does get a little bit trickier, right? Because when you have students doing work in a classroom setting, right, we've talked about Hazelwood will apply where it could be read as government speech. But when you tell a student to do a project, write a paper, pick a book, do an art project, as long as the student does their project within the confines of the assignment, the school doesn't have much leeway in regulating what that project looks like. So in this case, the school had an art show, and I suppose it was important that the little kids could attend the high school art show. And one student's art, which was quite good, depicted a woman's torso. And it was nude, but all of the, I'll say, important parts were covered. Right? Her chest was covered, the pelvic area was covered in flowers, so not even something particularly outrageous. And then the student had also painted a photo of a uterus in shackles and had put on the ball and chain property of the US government. And there were a couple of board members who really did not appreciate this artwork. and asked the superintendent to pull the artwork out of the show. On the theory, by the way, that this art was obscene. All right. So we'll just review quickly the definition of obscenity, which is work that appeals to the prurient interest, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. And I will say we apply a slightly different level of obscenity test when we're talking about exposing young children to things, but even with young children in this audience, there wasn't anything even borderline obscene about these paintings, okay? And given that there wasn't obscenity, that the level of nudity was probably mirrored in the European history textbooks that the school had, there was nothing that the district could do about this. When it came to the painting of the uterus, had the district tried to pull that down, I think they would have been subject to a viewpoint discrimination claim on that point, because that was quite clearly political speech. Same district. Two students worked together to paint a mural on the wall in the library. The mural depicted fantastical versions of the students. So not quite human looking. You know, one of them had, you know, really pointy ears, like it looked almost alien. They clearly weren't supposed to be self-portraits. One student happened to be much taller than the other. This was middle school, so no surprise there. One was tall, one was short. They were holding hands. In the background of the mural, they had painted a lesbian pride flag. This was, by the way, 5-6 years ago. So the mural had been on the wall for a while. But all of a sudden, a parent got it in their heads that this was child pornography. This was promoting pedophilia, and it needed to come down. And the board had a lot of public conversations about this and the fact that that was why they wanted the mural to come down. And we had a lot of not public conversations about how you can't just pick one mural with a lesbian pride flag and say it has to come down, and also how this isn't pedophilia or child pornography. Again, referencing definitions, you know, that we have in the law. And so ultimately, after a year of discussing this very publicly, they said, well, we want to do it anyway. I said, well, the surest way to get hit with a viewpoint discrimination lawsuit, because you've just been out there for a year talking about the fact you want to do this because you think these students are lesbians. So ultimately, what the school has decided to do is paint over every mural in the building. Just do away with all of the student art so that we don't have to talk about this one piece of student art. So moving from there, just briefly to touch on school libraries, because this is another issue that we've seen a lot about in recent years. Boards have almost total control over their curricular materials. The Ohio statute is up there. The key decisions at the federal level are there as well. Interestingly, you'll see the same two decisions on the next slide about school libraries. So both the Pico case and the Minarsini case found that boards could, you know, strictly regulate their curricular materials. Both of them also found that boards couldn't do much with library books once the book was in the library. And so we have seen efforts across the country recently to ban certain library books. They have not been particularly successful, at least in our Ohio districts, because of these cases. And with that, I will turn it over.
Thank you, Emily. Our final speaker for the morning session is Will Creeley. Will joined the Foundation for Individual Rights and Expression, acronym FIRE, in 2006, where he currently serves as legal director. As legal director, Will coordinates FIRE's legal advocacy and oversees FIRE's litigation legislative and policy reform, and targeted advocacy departments. He's appeared on national television and radio on FIRE's behalf and has spoken to thousands of students, faculty, administrators, and attorneys about First Amendment rights at events across the country. He is a co-author of First Things First, a modern course book on free speech fundamentals. His writing has been published in the New York Times, the Wall Street Journal, the Washington Post, the Chronicle of Higher Education, and others. He has co-edited FIRE's Guide to Due Process and Campus Justice and Guide to Free Speech on Campus, and has authored amicus briefs submitted to courts nationwide, including the Supreme Court. He serves as co-chair of the Education Subcommittee of the American Bar Association's section on administrative law and regulatory practice. He's a 2006 graduate of NYU School of Law, where he served as an associate executive editor for the NYU Law Review, a proud native of the shores of Lake Erie in Buffalo, New York. Will now lives in New Jersey with his wife and 2 children. And he will speak on the Mahanoy Area School District BBL case decided in 2021 regarding a disgruntled cheerleader's misguided teen spirit and her social media posts, and suggests that presented a missed opportunity.
Thanks, folks. It's a pleasure to be here. Thank you very much to Kennedy. Thank you very much to all the Law Review staff. Thank you to Professor Anton. And thank you to Eric Seiler for the work. And it's an honor to be here with my distinguished co-panelists. One of the problems with going last in the morning lineup, batting cleanup here, is that there's so much that's been said that I kind of want to ditch the 20 minutes I had planned just to talk, particularly about Emily's presentation, because it's a First Amendment attorney working for a free speech advocacy group. There's a lot to chew on there, Emily. I'm thinking about just start, if I may, briefly. What is FIRE? We're a nonpartisan nonprofit. We've been around since 1999. For much of our existence, until this past June, we dealt exclusively with higher ed rights, student and faculty rights. I actually had the pleasure of working there with Law Review alum and Case Western alum, Caitlin Patton, who's here today, and is now clerking for Judge Calabrese in the Northern District. And one thing about those library points that Emily just mentioned, PICO is undoubtedly weak, and this is not what I want to talk about, but I would very happily go for 20 minutes on it. And we are actively looking for students to strengthen PICO in the various circuits. So if you have younger siblings who are in high school who find themselves subjected to a partisan book ban, please direct them to thefire.org. We will leave no stone unturned in our search for plaintiffs. And as Caitlin knows, we will even send attorneys with 3 days notice to Nampa, Idaho, to talk to residents and local booksellers. If the school board there had followed a policy, maybe Caitlin wouldn't have got to explore the Boise area, but they didn't. So there we were. Yeah, so as I say, we've been around since 1999. We're proudly nonpartisan. My line when I meet folks is that I can give you 5 cases I've worked on that'll leave you thinking I'm a freedom fighter because you'll agree with the underlying politics. I can also give you 5 cases I've worked on that will make you think I'm the devil incarnate and everything that's wrong with America. So it's a nice way to meet folks at parties. I urge you to check out our website. I won't go into much more detail. Again, part of the other problem with going last is that some of your thunder has been stolen. So I won't go into too much of the framework that Emily very helpfully and much more concisely summarized than I will. But I will give you the pictures. There's John and Mary Beth Tinker with their iconic armbands from Tinker v. Des Moines. The basic rule here, absent a forecast of substantial disruptions of or material interference with school activities, the speech is protected. There's an important corollary here, which I ask everybody to keep their eyes on, because I think it is an emerging area of jurisprudence, particularly post-Mahanoy. The invasion of the rights of others prong in Tinker, which is mitigated to some extent by federal anti-discrimination law, or at least dictated by federal anti-discrimination laws like Title VI and Title IX. But watch that space. Because we have seen school districts advance the argument that while this speech may be protected off campus post-Mahanoy, and while this speech may be of political interest, it constitutes a violation, or I'm sorry, an invasion of the rights of others. What those rights are is somewhat hazy. So we'll get back to that in a little bit. There's Matthew Fraser, named plaintiff in Bethel School District number 403B Fraser. Folks may remember this when I'm speaking to high school audiences. This is the highlight of the speech where I talked about Tim Fraser's speech that he gave to his classmates, nominating a fellow student for a student government post. I won't read everything to you. Just let's say it's laced with sexual innuendo, and the court in 1986 did not find it funny. They said that, and one great thing is Professor Wilson's talk noted you get to use the verb inculcate a lot when you're talking about K-12 speech. The role of public education, the court opined, was to inculcate the habits and manners of civility as values in themselves conducive to happiness, and it's indispensable to the practice of self-government in the community and the nation. I'm the father of an 8-year-old and a 5-year-old. I'm often telling my children what I'm trying to do is inculcate the habits and civility, happiness in and of itself when you're quiet. So it doesn't always work. Moving on, Hazelwood School District v. Kohlmeyer, as Emily mentioned, this is the case involving the principal. There he is, Robert Eugene Reynolds, censoring student newspaper, The Spectator, by clipping out prior to publication articles on divorce and teen pregnancy at the school. I had the pleasure some years ago of attending a panel where for the first time, the student editor pictured here, whose name I'm forgetting, and the principal, Kohlmeyer, of course, and the principal saw each other for the first time since graduation. And the enmity was palpable. They still did not like each other. It was by far the feistiest panel. It was fascinating to me to watch. But yeah, so that the basic rule is reasonably related to legitimate pedagogical concerns and school-sponsored expressive activities. So well, skip this slide basically, but this has been pushed back on a lot by the Student Press Law Center, an excellent nonprofit that I'm proud to work with often. We've passed new voices legislation in a number of states, pushing back on the reliance on Hazelwood and overruling Hazelwood in both the K-12 and higher ed context. Morris v. Frederick, bong hits for Jesus, my personal favorite of the school cases for now. This is the students in Anchorage, Alaska, who unfurled the banner, as you see here, bong hits for Jesus. Nowhere in the court's opinion did you read the word joke. It happened off campus, but as Emily said, weirdly specific rule, schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as encouraging illegal drug use. Now, as noted, I believe in the concurrence, I want to say by Justice Alito, had this been a political statement, perhaps it would be different, right? The ambiguity of the joke, if I may presume it was a joke, I think it was a joke, although there's an interesting argument about religious speech there if you want it. Had you construed it as a joke or as a pro marijuana legalization banner, it might have been different. So K-12 online speech cases will be entering the jurisprudential desert here, right? So get yourself ready, right? This has been a long 15 years. Actually, let me first start by saying, when I joined FIRE in 2006, we were doing exclusively higher ed work. And when I talked to audiences of attorneys and educators, I would have to identify Facebook in a way that now seems long distant and anachronistic. I would have to say popular social network site, facebook.com. And some people say, oh, my kids. Yeah, no, I've got a cousin or a nephew who's on there. Yeah. And that seems like a long way away. One point that FIRE president, CEO, then legal director, and I made early on is that the difficulty presented by Facebook for administrators is real. You have been afforded a new kind of visibility into conversations that previously would have vanished into the ether. You can now hear the locker room conversation. You can now hear the conversation about a teacher or an administrator that students would have crossing the quad. What do you do with this powerful new visibility, right, with student speech? Do you render unto students in their private moments what is theirs, or do you monitor and attack? And we urged the latter, but the temptation was too great. And that was at the higher ed level. In K-12, it's far different. I could have picked any number of these cases. I picked Doniger v. Niehoff from the Second Circuit because the facts here remind me of a kind of classic PG-13 Disney movie. You know, let's get the band together and have a concert, but those dastardly school administrators are going to shut us down. It's a little bit like Footloose in that way. We had a student who's a member of the student council, and she wanted to criticize, or she had criticized the administration for rescheduling Jam Fest, which is the annual student concert. And there were some questions as to whether or not they could perform Jam Fest in an alternate location or an alternate date. She organized a letter writing petition and galvanized student and some parent support. The students and parents emailed the district. The secretaries who were receiving the emails apparently missed a few meetings. They had so many emails, their inboxes overflowing. My heart breaks for them, of course. And that was enough of the disruption. She called them douchebags to us, I remember. The volume of calls and emails received by two school officials in response to the students' blog post is sufficient evidence of a foreseeable risk of substantial disruption. So think about the civic lesson here, going back to Bethel, inculcating the habits of civility. And as Professor Wilson mentioned, right, the idea that we are teaching students for life, how to succeed in life in our pluralistic democracy. So here we had a student who's essentially punished for running a good advocacy campaign, right? For being civically engaged, an elected student official, and her punishment was that she could not run again. So I ask you what kind of lesson that is. Other circuits followed suit, applying Tinker to off-campus online speech. Again, I won't go through chapter and verse of these, but that was emerging as the general rule that schools could apply Tinker to reach out past the schoolhouse gates into the social media presence of their students. When students speak online or off campus, they must do so at their own risk. One last case I'll note that's particularly interesting, Bell v. Itawamba County School Board, involving a student who was an aspiring rapper and posted on his YouTube page a rap criticizing two phys ed teachers who had been allegedly sexually harassing female students. Again, kind of classic whistleblower activity that we might think of as essential to democratic functioning. The post and the verses included, I think, of the recent legislation passed in California about the use of rap lyrics as evidence. The posts were kind of classic rap posts with hyperbolic references to violence, etc. But the Eighth Circuit entertained the fact that they could have constituted a true threat against the named phys ed teachers. The dissent at the panel level said, what are we doing here? We are punishing off-campus speech for the impact it had on campus, but the impact was really just embarrassing the phys ed teachers. Goes up to, there's a fairly well-publicized petition for cert, had rappers like T.I. and Killer Mike signing on in support, kind of again beginning to galvanize this burgeoning movement to restrict the use of lyrics as evidence in criminal cases. So it's an interesting cultural moment, but the petition was denied. So that's where we have it when we get to the Cocoa Hut, and there is the Cocoa Hut. And one day I'm going to go to the Cocoa Hut, and I'll post it on my Twitter feed, so stay tuned. But that is the Cocoa Hut. And really, I'm talking about this mostly because I just wanted a piece of scholarship about that. It said what happens at the Cocoa Hut does not stay at the Cocoa Hut. And this is where VL and her friend, oh, there we go, go and post their fuck school, fuck cheer, fuck everything post, right? On a Saturday night at the Cocoa Hut. And one thing about Mahanoy that was interesting, actually came up in the dinner last night, that when Fire submitted our amicus brief to the Third Circuit in support of the ACLU of PA's position and BL on her First Amendment case, really the grounds on which we were fighting at that point was whether or not you had a right to be a cheerleader, right? Whether that constituted sufficient punishment for First Amendment rights to attach, or whether by joining an extracurricular group like a cheerleading group, she had waived some of those rights, right? You don't have a right to tell your football coach, if you're the quarterback, to go to hell, right? He can make you run laps. Whether or not he can kick you out of school is another question. Actually, that raises, just as a quick aside, that raises interesting questions in the higher ed sphere, where FIRE has argued that relying on First Amendment protected speech to deny a student without due process an academic scholarship or revoke an academic scholarship, when that academic scholarship is the but for of how to go to this public school, might implicate important First Amendment interests. And that's an interesting case we're still waiting on in the Second Circuit, involving a Radwan, Noriana Radwan, who's a soccer player for UConn, who in victory gave an ESPN camera the finger and lost her academic scholarship as a result. So kind of stay tuned for that one. That one's been out for a while. We should get that soon. Anyway, putting that aside, that's not the grounds that the Third Circuit decided Mahanoy on. The Third Circuit instead decided to flip over the table and say, we're tired of this wandering in the desert. We're tired of the mishmash of circuit approaches. And we don't think that the school officials in K-12 should be able to reach the long arm out into social media posts. And they said instead, to enjoy the free speech rights to which they're entitled, students must be able to determine when they're subject to school authority and when not. And finding that the interests that schools serve, acting in local parentis, educating and inculcating values, etc., those cut off when students walk off campus. And they proposed a fairly bright line. On campus, subject to school control. Off campus, you're on your own. The Third Circuit importantly did reserve the question, this gets lost often, as to off-campus student speech that threatens violence or harasses others. And I think that was an important reservation that got lost somewhat in the briefing. The district appealed and we went to the High Court. Some of the briefs for the High Court were particularly noteworthy. The American Civil Liberties and Justice Association, the ACLJ, did I get it? American Center for Liberty and Justice filed, thank you very much. I can never, there's too many acronyms, I can never remember that one. They filed an interesting brief arguing that, in support of neither party, arguing that, frankly, if anybody should take an action, it's the parents, right? It's not the school's responsibility. It's not the student's right, per se. The party that is empowered and best equipped to take action would be the parents. That was an interesting argument from a conservative advocacy group. The school boards argued in favor of their power, that to be able to run the school, they have to be able to monitor social media in this way. First Amendment advocates like FIRE, the National Coalition Against Censorship, and the Comic Book Legal Defense Fund, which joined our brief, argued otherwise. We argued that the Third Circuit got it right, that there is stability and clarity in the precise on-off distinction. And we compiled a long list of examples of students getting punished. And some of Emily's examples would have been very helpful. I was writing this brief of students getting punished for off-campus speech, quoting Mean Girls, posting a picture. One student posted a picture with her brother, both of them wearing, I think it's called shadets, Middle Eastern face coverings, with their legally owned firearms, and saying, we're off to exercise our Second Amendment rights, and this is me exercising my First Amendment right. It's fully off campus. Licensed gun owners had students taking pictures of lawfully owned firearms and saying, if you know where the zombie apocalypse, when the zombie apocalypse hits, you know where to find me. Picture of a toy gun, posts of cheerleaders next to Trump signs, posts of students next to Black Lives Matter signs, basically the world in a nutshell, everything Emily described. So we found all this wide variety of speech that should be protected off campus, but nevertheless resulted in punishment. Even speech, frankly, that's just kind of a low level and jokey. Not only the Mean Girls quote, but a senior at a high school in Massachusetts who said, there's a snow day, hashtag fuck off, hashtag seniors, right? And that was that. And that was, and he was, he's punished for it. So again, what we argued is that the educational impact, the pedagogical takeaway here for students is that you live in a panopticon. You can never escape the state. It will always watch you. There is no offline. When you go home, whatever you write will be monitored. Your friends will rat you out. You better keep your mouth shut, especially if you're talking about anything controversial. It's an interesting case that goes up to the High Court. It could very easily have been the straight pride flag, right? Or it could have been thin blue line pictures. It could have been, I hate Black Lives Matter. It could have been, I love Black Lives Matter, depending on your district. But this one went up. So we also pointed out that what happens here, and again, given the fact that we did higher ed advocacy for almost 21, 22 years now at Fire, we pointed out all the analogs at college, because high schoolers often become college students. And when they do, they continue to post offline, and they continue to be punished for those posts, right? We had a student who was in a messy breakup, and his girlfriend wrote pretty incomprehensible and grammatically flawed letter to him, breaking up with him. So he screenshot the letter, marked it up in red pen, and posted it to Twitter. It went massively viral. And he was suspended as a result of posting that letter under Title IX. So it hits the court, and we won't go too far. I will assume some familiarity with the outcome of Mahanoy. Although, did anybody ever actually see this picture? I'm not sure how many people actually saw the picture. This is the famous post, right? And note that all you've got is someone taking a picture of a picture. Right? This is what made it up. I think it should be on a T-shirt somewhere. It's interesting. So in Justice Breyer's fashion, he didn't give us the bright line rule. In fact, he walked back the Third Circuit's bright line rule. He explicitly rejected it. Said instead what we have, instead of a rule, we're going to have just a kind of general sense of 3 features of off-campus speech, right? Off campus, you don't have in loco parentis. We cannot have the panopticon. We cannot teach students that they're under 24-hour surveillance. And this is the interesting one. The school itself can perform an educational function by teaching students that unpopular speech is protected in our pluralistic democracy, called schools the nurseries of democracy. Let's just have a very quick look, and I've screwed up. I left all my time on the cutting room floor, so you'll have to stay tuned for the article. But what I'll be writing about is what Mahanoy means, because we celebrated. You could have heard me. Caitlin will remember from the office. I was very loud and very happy when it came down. I did not think it was going to come down. Since Tinker, every K-12 decision has cut away at student speech rights. This one, again, in somewhat a mushy way, held the line. So I thought, great, this is a victory. All kinds of flowery dicta that I'll be quoting until the end of time. But the rule itself is less certain. But so far, the test is interesting. Here's C1G v. Siegfried, which Fire participated in as amicus, where this Snapchat got a student suspended. Me and the boys about to exterminate the Jews. This is Friday night at an Amvets or something like that, where like a thrift store, they're trying on, you can't really see it here, but they're trying on military hats. And that was sufficient for the suspension. There's an apology. There's no substantial disruption to the school beyond one parent calling in saying what's going on. There was a news report that the school had been, let's see if I got it here. No, I don't, but there was a news report the school had been, sheriff's office investigated, there was no threat. So the 10th Circuit actually reverses the district court here. The district court says applying Tinker is fine, and this Mahanoy has nothing to do with it here. But the 10th Circuit reverses and said, this is controversial speech, but relying on Mahanoy said it's protected. There was no real disruption. And really quickly, I'll just give you a couple other cases, and then I promise I'll stop. Thank you. Courts thus far have found Mahanoy fairly easy to distinguish, right? And most of the claims thus far have not squarely presented Mahanoy issues. Doe v. Hopkinton Public Schools is out of Massachusetts. It's disturbing for another reason. This is 2 students who were punished for participating in a group chat about a 3rd student on the hockey team. The 3rd student did not know about the participation of the 2 students who were punished. He was unaware of the posts. There was no disruption. The students only posted 3 or 4 times in an otherwise lengthy group chat, but simply by being members of that group chat and participating in it, they were found guilty. And we argued it was guilt by association, but interesting argument. One final note, professionalism cases, thinking about professional standards for teachers. We have ongoing Fire litigation on behalf of Kim D.A., who's a pharmacy student at University of Tennessee, who was expelled and then reversed the expulsion after Fire's intervention for her sex positive posts and under an anonymous name on Instagram and Twitter. And I'll wrap it up there, but stay tuned. I'll have more. I look forward to your questions. Thank you very much.
Thank you, Will, and thank you to all our panelists. We have about 17 minutes for questions and answers. And I think somebody will be walking around with a microphone. So if you can make sure to ask your questions into the microphone, I think just raise your hand if you would like to ask a question.
This is for Professor Duncan. Couple quick questions. One, where does homeschooling fit into your picture? And second, if the government does provide funding to students, to what extent does the government have the ability to try to persuade parents to send their kids to public rather than private schools?
On the homeschooling issue, I think it's a bit difficult I think the public schools could, I think the state could probably limit the vouchers to accredited schools. But I think the Arizona one that just came down, the Universal School Choice Learning in Arizona includes homeschools at least to the extent they can use the funds to purchase materials and things like that. I personally would include homeschooling in the program, limited, not so the parents can basically put themselves on an employment salary or anything, but I would limit it to materials. Now, to the extent, how can the public schools try to persuade parents? What type of persuasion are you talking about? Putting out, I mean, they could certainly put out notices.
So I'm just talking about advocacy. Every year when when the money comes out, the question is where do you redeem the money? To what extent can the government, in other words, advertise or try to encourage parents to send their kids to public rather than private schools?
Yeah, I personally don't think there'd be a problem with government speech saying what a wonderful curriculum we have, what a wonderful program we have in the public schools. Please use your vouchers to send your children to us. I don't think that affects the parents' First Amendment rights. And I think it is government speech saying what a great program we have. So I wouldn't have a problem with that.
My question is actually for both Richard and Erica, because based on what I know, I think in response to Emily, I think that it actually is not incredible that there are students who honestly don't know what a Confederate flag means, given the quality of the education about the history that takes place in some of the United States. So I guess the question is, to what extent it's appropriate to control the content of the curriculum. Of course, as Richard knows, in the Zellman case, the Supreme Court approved of vouchers, but the vouchers included a condition that the school not teach hatred of any person or group on the basis of, and it listed some characteristics. So I guess my question for Richard is whether it's appropriate to do that. And I guess my question for Erica is how important it is to have criteria that refer to the dominant white patriarchy as opposed to just stating specific propositions that the students need to be told of: the history of slavery and segregation, the role of slavery in the Constitution, why the South seceded, why Reconstruction failed, the Great Migration, the economic history that produced disproportionate Black poverty in the United States. These are facts. And so I guess I suggest that this is the appropriate thing to push for in the public school curriculum. And my question for Richard is, to what extent it's possible, if we're going to support private education, Pierce versus Society of Sisters says you can have curricular requirements that isn't enforced the way that it used to be, to what extent that is appropriate with respect to private education.
I hate to fall back on the word reasonable, but I do think that
the specific proposition I cited.
I do think the government has the power to impose reasonable regulations covering the kind of curriculum that satisfy mandatory attendance laws. And I think that's true with respect to private schools as well as public schools. I get a little bit nervous when there are specific viewpoints that are being imposed on the curriculum. So, you know, I guess it would really depend upon exactly how demanding they're being in terms of the viewpoint that's being. But if the regulation was something like you have to teach all of American history, including the history of slavery, I'd have no problem with that. If the regulation was you have to teach 1619 rather than 1776, then that might well be problematic. That might begin to look like.
In response to the question that you posed to me, I think, right on its face, there's absolutely the state can impose reasonable regulations and say the curriculum has to include facts. But what happens in reality is that the education the students were receiving before all of this controversy was never value neutral. And sadly, in many places, we can't agree on what's facts. I mean, I have law students who told me that they were taught in textbooks that the Civil War was the war of Northern aggression. I mean, I think if one did a survey of traditional social study and history books, there are many problematic things that are in those textbooks that completely went uncovered until this current controversy came about. So I think the challenge really is education is not value neutral. On that, I would agree with Professor Duncan that we are espousing values even when we teach facts. I think the problem is that we can't come to a consensus on whose values we are teaching. And to the extent that this has not been a true multiracial democracy, many of the values that have been taught, at least insofar as race and inequality are concerned, have been values that probably is accurate to say are taught from a particular perspective and paradigm, particularly where I'm at in the South. I'm flabbergasted at what some of my students told me they actually had in actual textbooks that perpetuates a view of a particular ideology or a view of the world that is problematic in terms of true inclusion.
So 2 quick questions. Thanks for a great panel. Professor Duncan, if the idea is to allocate the per pupil expenditure to each student, I wonder what is, and this isn't really a speech question, but an equality question differently, what's the basis? Does that happen at the state level, at the national level, at the school district level? And how do you account for both residential segregation and inequality in a plan to try to make parents the drivers of what they want to teach their kids, especially around transportation and all of the sort of things that get in the way of or that can be barriers to that? And then my question for Emily is, doesn't this doctrine about disruption, and I mean, I've thought this for 20 years, so I'm just asking if you see any ordinary people thinking about it this way. It incentivizes creating disruption. And so instead of the dispute or the topic being sort of rationally discussed, if you want to pursue something, are we incentivizing disruption through the doctrine? And maybe it doesn't matter, but I'm just think it's an interesting question.
On the question about where the funding comes from, I guess it depends. If the court were to hold, which it won't, at least not in the foreseeable future, if there's a constitutional right to equal funding, that decision would have to be implemented with all deliberate speed, because it's a very complicated issue, because funding comes from everywhere. There's local funding, there's state funding, there's some federal funding. So it wouldn't be an easy ruling to implement. It would be. But in terms of this coming on at the state level, I think most of where we're seeing the school choice laws coming down, they're not coming down at the local level, they're coming down at the state level. And so they're just providing sort of equal access to state funds, which I think still means, you know, the state funding, part of it is $7,000 to $13,000. I think that would mean that, you know, that families would get the 7, not the full 13 in terms of the way they're doing it at the state level. But that kind of universal school choice law, I think, is still very important. It should be more than a little bit, because a little bit helps me, right? Because I just kick in the rest, but a little bit of scholarship funding.
It would
doesn't help the
equalize
poor.
inner city schools.
It doesn't help the poor. And, you know, and I think a lot of the proponents of school choice are inner city families whose kids are trapped in often segregated, racially segregated inner city public schools, and often low performing public schools. And so I think a lot of the support for school choice comes from young inner city families, which are often disproportionately persons of color, families of color who are supporting this. So it's not easy to implement if it's done by a Supreme Court decree. It's easier to implement at the state level because you just write the bill.
And as for the disruption incentive issue, yeah, I mean, I think the current state of the law probably incentivizes administrators to find a disruption. I spend a lot of time telling people to take a deep breath and step back and realize nothing's actually happening.
Personally, thank you for that. I want to know, you've identified a crucial flaw in Tinker. The heckler's veto problem, as you describe it, is absolutely present in Tinker. There is indeed an incentive to say, as the burly guy told the cop in the Ferber back in the 50s case with the man on the literal soapbox talking in, I think, Rochester, New York, about racial inequality. The burly guy says to the cop, at least in my mind, he's a burly guy. I can't remember if that's actually in the record. But the burly guy says to the cop, are you going to shut him up or am I going to shut him up? And there's a little bit of that still in Tinker, right? If you, let's say someone's flying, you know, thin blue lights flag, and one student says, either you get that out of this parking lot or we're going to burn down that car, right? And tells an administrator that, we got a reasonably foreseeable disruption, right? I mean, so, yeah, no, there's a big heckler's veto problem in Tinker.
And normally the heckler is the one who ought to be regulated, not the speaker.
Well, yeah, right. So you've got a line of, yes, yeah, absolutely.
Anyone else have a question?
Someone's ahead of me.
I'm like big bag into the room.
So some of you might know Williamson County, Tennessee, which is where I'm from. And or I live now, but one of the issues that we're dealing with in our district is the regulation of classroom libraries. And I would be curious as to your perspectives, maybe like Emily, and then also from a CRT and creating a space that is for all students. If Ms. Wilson could also speak to that, I appreciate it.
Sure. So I think the classroom library, more than the school library, also raises some academic freedom concerns that I think the afternoon panel will probably touch on as well. But there are more issues there with regard to the teacher being the speaker and having some right to exercise control over supplemental materials in the classroom. Now, when it comes to actual curriculum supplements, courts have said, you know, even where districts have granted teachers discretion, the teacher actually doesn't have any right to use particular curriculum supplements. So the board can always step in there. When it's not a curricular supplement, the teacher just makes it available. It's a much grayer area. And I don't think we have clear direction yet on it. I suspect we're going to start getting some cases there. But there's certainly an academic freedom argument to be made when the teacher is stocking their own classroom library. And I think we would probably look at similar principles to apply to the school library in terms of what you can put in there. There are restrictions on what can go into a school library when you get to, you know, really extreme material that wouldn't be appropriate for the K-12 audience. Those same rules would apply to classroom libraries, and beyond that, I think we're gonna see soon where courts want to come down on this. But I think there are legitimate academic freedom arguments to be made there.
Yeah, I would agree with everything that Emily said there in terms of academic freedom, particularly for teachers in their own libraries. One thing that I've started to think about, because we've had some of these issues in North Carolina as well in terms of book bans and regulations in the classroom, is whether or not there's actually an offensive attack to be made on equal protection grounds when you look at the books that are being excluded and the students who are being impacted by the exclusion of those books. I mean, pretty innocuous books, anything with a Black author or Black subject in some of our counties is being dinged as something that shouldn't be in the classroom. So I think part of the challenge in terms of this legal and political fight is not always being on the defensive and making some offensive claims as well.
Just to weigh in on Professor Wilson's good point, there's litigation right now, both in the state of Florida against the quote unquote Stop Woke Act. FIRE has a lawsuit there. We're litigating alongside the ACLU. The ACLU, as I recall, did bring an equal protection claim in that context. There's also an Oklahoma case, again, brought by the ACLU, which I believe also has an equal protection claim with regard to bans on quote unquote divisive concepts. So yes, stay tuned.
We'll take one last question.
So just a thought about strategy here. I think that I agree with Erica that there's no value-free education. There's no value-free history. There's just way too many facts in the past, and so you've got to pick and choose which facts from the past you are going to teach. I mean, the deep problem with at least some of the anti-CRT legislation is that it prohibits teaching certain things that are true because teaching things that are true could be divisive. So it's just going back to the ignorance about the meaning of the Confederate flag. There are people out there who think Confederate flag means I'm a rebel, and that's all they don't know any history, they don't know anything, So I think that the ground on which to fight is to say, well, is it okay to include in the curriculum, for example, the South Carolina Articles of Secession, where they say, this is about there's a president who's against slavery, and we can't endure that. And they say we're seceding because of slavery, because we need to keep enslaving African Americans. That's what we are fighting about. There's a value judgment about whether students need to be taught that, but I'd really like to be fighting with the people on the other side and put them in the position of saying, no, that's a fact about which it's important to us that Americans remain ignorant.
All right, well, let's call that the last word and end our session. Thank you. That's the last word. I guess we reconvene at 1 o'clock.